Fact 3. Habeas corpus. Overview. Latin for that you have the body. In the U.S. system, federal courts can use the writ of habeas corpus to determine if a state's detention of a prisoner is valid. A writ of habeas corpus is used to bring a prisoner or other detainees, example, institutionalized mental patient, before the court to determine if the person's imprisonment or detention is lawful. A habeas petition proceeds as a civil action against the state agent, usually a warden, who holds the defendant in custody. It can also be used to examine an extradition process used, the amount of bail, and the jurisdiction of the court. See examples: Knowles versus Mrzeyes 556 U.S. 2009, Felker versus Turpin 518 U.S. 1051 1996, and McClensky versus Zant 499 U.S. 467 1991. Federal Rules of Criminal Procedure, Title V, Venue, Rule 18, Place of Prosecution and Trial, 28 U.S.C. former Section 114, now Section 1393, 1441, provides, all prosecutions for crimes or offenses shall be had within the division of such districts where the same were committed, unless the court or the judge thereof, upon the application of the defendant, shall be ordered to cause to be transferred for prosecution to another division of the district. Virginia Law Registry, Volume 44, August 1914, Number 4. Habeas corpus jurisdiction over federal and state court. General statement. It is a settled doctrine that a court of competent jurisdiction having possession of a person cannot be deprived of the right to deal with such persons by habeas corpus until its jurisdiction is exhausted, and that no court of another and independent sovereignty has the right to interfere with such custody. In Reed Johnson 167 U.S. 120 125 42 LED 103. Andrews versus Swartz 157 U.S. 272 276 39 LED 42 Ex parte Siebold 100 U.S. 371 375 25 LED 717. In Reed Woods 140 U.S. 278 290 335 LED 505 Pepke versus Cronin 155 U.S. 139 LED 84. Both federal court and state court are sovereign. That means if the federal court has possession of a person for a criminal offense, the state can't gain custody of that person until the federal court is finished trying that person. The only way state can get custody of an individual is through a habeas corpus. There are rules and procedures to habeas corpus that date back to the 1600s to protect the prisoner's rights. So unless the defendant puts an application in for a writ of habeas corpus or allows it to be put in, they cannot issue that prisoner back and forth from one sovereign court to another. Pursuant to the due process law, the defendant has a right to be tried in the court that possesses him before he is transferred into the custody of another sovereign court to be arraigned for a crime. However, Dr. York's attorneys allowed his rights to be violated and had him shuffled back and forth from federal custody to state custody and back into federal custody to help them build a case against Dr. York, because neither state or federal independently had enough culpable evidence on Dr. York. They had to use prejudice to convict Dr. York, not evidence. That is why Dr. York's name was in the media so much, assassinating the characteristics of his doctrine and him before the trial proceedings ever began. That is why they used excessive force when raiding the land and during the trial proceedings. The Nawapians did not have any history of violence whatsoever. They did not find any stockpiles of weapons. So there was no reason for a myriad of armed officers with assault rifles to be outside Dr. York's courtroom or used in the raiding of the Nawapians' land Tamaray at 404 Shaderdale Lane, or in Dr. York's legal residence in Athens, or in Dr. York's car. That was to gain apathy for Dr. York in the eyes of the public. It was a prop. Fact 4. Judge jurisdiction to try the case. 28 U.S. Code Section 455, disqualification of justice, judge, or magistrate judge, A, B, 2. Any justice, judge, or magistrate judge of the United States shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. He shall also disqualify himself in the following circumstances: where in private practice he served as lawyer in the matter in controversy, or a lawyer with whom he previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it. Judge C. Ashley Royal did not have the right to reside over the case of Dr. Malachi Z. York because he was in direct conflict of interest. Dr. York's wife, Shalimar Richardson, who resided at and had share ownership of 404 Shadydale Lane in Eatonton, Georgia, and her family had a civil suit against Navicent Health Medical Center, then known as Oconee Regional Medical Center in Milledgeville, Georgia, for her father, who died as a result of their malpractice. Judge C. Ashley Royal was the attorney representing the hospital against Dr. York's wife and her family. He lost the case. Sometime after this, he became a judge for the federal courts. So he was in direct conflict of interest and should have, upon request by Dr. York's attorney, recused himself from the case. But he refused to, claiming that he could be impartial. Although at various points throughout the pre-trial and trial hearing, he exercised his prejudice by acting as prosecution during these proceedings. All of this pre-trial and trial transcript information is available for anyone to review online at liberiafreedryork.com and nawapianfacts.com. He also refused to reschedule the trial in commemoration of the federal holiday Dr. Martin Luther King Day. Instead, he violated government law and opened the government business to conduct a federal trial, which tells you right here that it was racially motivated as well. Fact 5. Zoning and Building Code Battle. From 1997 to 2001, Dr. York and the Nawapians were in legal battle with the city of Eatonton, Georgia because of building code and zoning violations. We were constantly railroaded when it came to getting zoning and building permits to build our spiritual retreat in Egyptian theme park. We later found out that 404 Shadydale Lane was smack dab in the center of their future building projects and interfered with those plans. However, at the time, we didn't realize that is one of the reasons they gave us such a hard time with the zoning and building permits, well, along with blatant racism. So they would have the sheriff of Putnam County, Sheriff Howard Sills, acting as code enforcer to stage surprise raids in the guise of inspections on the land to inspect every building. He came to the land on several occasions. Never once did he report back to his officials that he witnessed a stockpile of weapons. If he did, then they would have brought forces on the land then for illegally stockpiling weapons without a permit. But this was one of his bases for encouraging the federal raid on the land with the excessive force of over 300 agents and local law enforcement. Nor did he witness any signs or indications of abuse in any form during these inspections.